We are ready to begin. I will count down from five and then we'll start. Five, four, three, two. The Subcommittee on Workforce Protections and the Subcommittee on Civil Rights and Human Services will come to order. Welcome, everyone. I note that a quorum is present. The subcommittees are meeting today for a joint hearing to hear testimony on phasing out subminimum wages, supporting the transition to competitive integrated employment for workers with disabilities. This is an entirely remote hearing, and as such, the committee's hearing room is officially closed. All microphones will be kept muted as a general rule to avoid unnecessary background noise. Members and witnesses will be responsible for unmuting themselves when they are recognized to speak or when they wish to seek recognition. If a member or witness experiences technical difficulties during the hearing, please stay connected on the platform. Make sure you are muted and use your phone to immediately call the committee's IT director, whose number was provided in advance. Should the chair experience technical difficulty or need to step away, Chair Bonamici or another majority member is hereby authorized to assume the gavel in the chair's absence. In order to ensure that the committee's 5-minute rule is adhered to, staff will be keeping track of time using the committee's remote timer, which appears in its own thumbnail picture. Members and witnesses are asked to wrap up promptly when their time has expired. Pursuant to Committee Rule 8C, opening statements are limited to the chairs and ranking members. This will allow us to hear from our witnesses sooner and provides all members with adequate time to ask questions. I now recognize myself for the purpose of making an opening statement. Today, we are meeting to discuss a proposal to phase out the 14C subminimum wage and help workers with disabilities transition to competitive integrated employment. Each person in this country deserves access to equal employment opportunities. Yet one of our foundational labor laws, the Fair Labor Standards Act, still allows workers with disabilities to be paid less than their peers. Under Section 14C, employers can obtain certificates that allow them to pay individuals with disabilities subminimum wages. These certificates have effectively eliminated any minimum wage for workers with disabilities. For many of these workers, the estimated hourly wage is roughly $2.50. For too many, it is even less. We should all agree that no American worker should be earning a measly $2 an hour. But opponents continue to argue that phasing out 14C certificates will burden businesses and restrict opportunities for workers with disabilities. The evidence says otherwise. 11 states, New Hampshire, Maryland, Alaska, Oregon, Maine, Washington, Hawaii, Colorado, Delaware, Vermont, and Wyoming have either phased out 14C or have no active certificates. Many of these states have taken the initiative to ensure individuals with disabilities can continue to their local economies, can contribute, to their local economies and work in competitive employment alongside people without disabilities. Even in states with 14C certificates, many providers have discontinued the minimum wage in favor of inclusive workplaces that meet the needs of both employer and worker. And while many workplaces across the country have shifted away from 14C certificates, we know that some states have struggled to find appropriate and meaningful alternatives. So today we will discuss legislation, the Transformation to Competitive Integrated Employment Act, that would help providers to shift their business models to hiring workers with disabilities in competitive integrated employment. This bill incentivizes states and employers who currently use 14C certificates to work with the disability community towards updating business models and creating fully integrated and competitive employment opportunities. Simply put, with the right supports, anyone can achieve competitive integrated employment if they choose to. It's up to us in Congress to provide the support that workers with disabilities need to succeed in our economy. I now recognize the distinguished ranking member of the Subcommittee on Workforce Protections for the purpose of making an opening statement.
I thank the chair. And before I begin, I would like to make a couple points. I must first urge the majority to begin holding hearings in person. The American people, the people we are elected to work for, show up for work. We should be no different. In fact, the people that we're discussing that may have disabilities are eager to get to work and would welcome the opportunity to come to work. Yet, my Democratic colleagues can't seem to come to the hearing room and do the business that we should be doing for the American people here in Congress. Having said that, I just want to say that Democrats and Republicans both want what is best for people with disabilities. We want these individuals to find rewarding work, get paid a fair wage for their contributions, and live fulfilling lives. Every human life is important, and every person should be free to pursue their happiness and reach their full potential. Federal laws set standards employers must meet to protect their workers. The Fair Labor Standards Act, or FLSA, establishes standards for minimum wage, overtime pay, and other workforce protections for private and public sector employees. Section 14C of the FLSA authorizes the Secretary of Labor to allow employers to compensate certain individuals with disabilities at wages commensurate with their productivity. These processes use special certificates issued to employers, commonly called 14C certificates. A Department of Labor 14C certificate offers individuals with disabilities a chance to contribute in the workplace, engage with other workers, and develop new skills. Republicans believe 14C certificates combined with competitive integrated employment opportunities have been successful in helping individuals with disabilities find the best and highest paying jobs possible for their unique circumstances. It is worth dispelling several myths about 14C work environments. First, it is not true that employers with 14C certificates accrue a financial benefit because of the arrangement. Second, it is not true that 14C workers are somehow trapped in their jobs. These individuals are fully able to explore other employment opportunities as they receive job coaching, referrals, and readiness services. Third, it is not true that all 14C employees can work in competitive integrated employment environments. Available research shows that those with significant disabilities will lose their jobs if the 14C system is terminated. Republicans support the ability of individuals with disabilities to access employment opportunities in a setting of their choice. I'm concerned that eliminating 14C as proposed by HR 2373 would have terrible consequences for many workers with disabilities. I look forward to hearing the witnesses' insights on this important topic. Thank you, and I yield back.
Thank you very much, Mr. Keller. I now recognize the distinguished chair of the Subcommittee on Civil Rights and Human Services for the purpose of making an opening statement. Chair Bonamici.
Thank you, Chair Adams and ranking members Keller and McLean, and thank you especially to our witnesses for joining us today. Today, workers with disabilities in several states can legally be paid less than the federal minimum wage. The U.S. Commission on Civil Rights recently issued a report that found that more than 100,000 workers with disabilities have been subjected to subminimum wages averaging an estimated $3.34 per hour. Phasing out subminimum wages for workers with disabilities is fundamentally a civil rights issue. The 14C subminimum wage provision in the Fair Labor Standards Act of 1938, or FLSA, is a relic of an era when employers were legally permitted to discriminate against individuals with disabilities in the workplace. And workers with disabilities did not have access to federal protections. It is far past time that we phase out this harmful provision that denies equal opportunity for many workers with disabilities. Since the FLSA first passed, thanks to generations of advocacy, Congress has passed several key laws to guarantee students and workers with disabilities the education and workplace rights they deserve. The Individuals with Disabilities Education Act, for example, provides children with disabilities access to free and appropriate education. The Developmental Disabilities Bill of Rights provides people with developmental disabilities the opportunity to design and access community services, individualized supports, and other forms of assistance. And the Americans with Disabilities Act guarantees equal opportunity for individuals with disabilities in all areas of public life. And now, decades after the enactment of these federal protections, Congress must make sure that workers with disabilities can earn fair wages and succeed in the workplace. States across the country, including my home state of Oregon, have already enacted legislation to eliminate the 14C subminimum wage and successfully transition workers into integrated and competitive work. But a recent GAO report also found that many employers and workers with disabilities do not have the appropriate resources or services to transition to competitive integrated employment. We need to phase out this outdated policy for all workers with disabilities, regardless of where they live. So I'm pleased to support Chairman Scott's Transformation to Competitive Employment Act, which would make sure that states and employers that currently employ workers using a 14C certificate can provide workers with disabilities the support they need to transition into fully integrated and competitive jobs. We must take bold action to make sure all Americans have access to equal employment opportunities. Thank you, Madam Chair, and I yield to the distinguished acting ranking member, Ms. McLean, for the purposes of making an opening statement.
And thank you, Ms. McLean.
Thank you, Madam Chair. First of all, I want to express my frustration and sadness as well, and echo what my friend Representative Keller said, how disappointed I am that this hearing is entirely remote. We are one of the last committees still not meeting in person, and it's really time to get back to the work of the people and get back to in-person events. With that said, I think my friend Representative Keller said it best. Work, by its very nature, is dignifying and important for all individuals. Our job is to help as many people as possible pursue pathways to success. As Representative Keller stated, a DOL 14C certificate offers individuals with disabilities a chance to contribute in the workforce, engage with other workers, and develop new skills. We must honor and uphold this flexibility. Sadly, it appears that the Democrats' good intentions would result in a misguided public policy. The unemployment rate for people with disabilities is tragically high already. HR 2373 strips workers' self-worth by eliminating jobs opportunities. Employers with 14C certificates are not artificially keeping paychecks low. They are giving individuals an opportunity to contribute where no opportunity existed. By advocating for the elimination of 14C program, Democrats are effectively turning their backs on some of our nation's most vulnerable workers. A one-size-all DC mandates are rarely effective, and this proposal is truly no different. To try and reduce the inevitable fallout, the bill authorizes $300 million in taxpayer-funded competitive grants to affected states and businesses. Throwing taxpayer dollars at states and a handful of employers will not make up for the job lost opportunities. The legislation's phasing out of 14C, combined with Democrats' efforts to double the national minimum wage, will force these employers to actually downsize. And unfortunately, tens of thousands of laid off individuals will have no hope of finding meaningful employment opportunities, and they will lose the more important benefit of actually having a job. My friends across the aisle claim that the existing system segregates people with disabilities and is detrimental to everybody's interests. This cheap rhetoric misstates the reality. As Dr. Putz describes in his testimony, there are legitimate instances where the 14C environment is appropriate. Differently situated workers may want different work environments, and we must respect those workers' choices. Presumably, Democrats called this hearing because they want to help. But H.R. 2373 is not the solution. Democrats claim the solution that the Democrats claim it's to be. We should carefully weigh the evidence, the actual evidence, before eliminating a meaningful and successful program. Thank you very much, and I yield back.
And thank you very much for your comments. Let me now, without objection, all other members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5 p.m. on August 4th, 2021. I'd now like to introduce our witnesses. First of all, we have Nantini Kopstein, who is the mother of an adult daughter with multiple cognitive and auditory disabilities and is an effective advocate for people with disabilities, including in her role as a board member of the New Jersey chapter of the Association of People Supporting Employment First. John Anton is a legislative specialist with the Massachusetts Down Syndrome Congress and an ambassador to the National Down Syndrome Society, who advocates for legislation to improve the lives of people with disabilities. Dr. Matthew Putz is the Chief Executive Officer of Employment Horizons, Inc., a nonprofit community rehabilitation program in northern New Jersey that provides a variety of employment services to people with disabilities. And Neil Lowe is the Executive Director of Blindness Initiatives at the National Federation of the Blind. He has previously held other leadership posts within the NFB and managed employment programs for people with disabilities. Want to thank all of the witnesses. We appreciate your participation today. We look forward to your testimony. Your written statement will appear in full in the hearing record, and you're asked to limit your oral presentation to a 5-minute summary. And after your presentation, we'll move to member questions. The witnesses are aware that their responsibility to provide accurate information to the Joint Subcommittee, and therefore we will proceed with their testimony. I'd like to first recognize Ms. Kopstein. You are recognized now for 5 minutes. We'll hear from Ms. Kopstein, you are recognized for 5 minutes.
Thank you. Good morning. Thank you for the opportunity to testify in support of the Transformation to Competitive Integrated Employment Act, H.R. 2373. Today, I draw upon my lived experience as a parent of Monica, a 33-year-old individual with cognitive and developmental disabilities, auditory processing deficits, seizures, and bleeding disorders. My testimony does not necessarily represent the views of any organization of which I'm a member, including 2 governor-appointed statewide councils. And I may add, I have been appointed and reappointed by both Republican and Democrat governors of New Jersey. I have graduate degrees in economics and have also worked as an economist. I've lived in New Jersey since 1986 and have enjoyed an extensive network and friendship with individuals with disabilities and their families, largely through my daughter's participation in Special Olympics activities and my own active advocacy. The network and observation of events during my college years in America from 1969 have given me a voice to advocate for our daughter, Monica, who was fortunate to have graduated from a public high school with a decent school-to-work transition program, but no paid employment when she left school in 2009. 1 year before her final year at high school, Monica and I visited 3 sheltered workshops following the recommendation of her school's transition team, which viewed her as being too disabled to work in the community, even though she had had 2 paid summer jobs as camp counselors. Neither Monica nor I had positive impressions of the 3 14C entities we visited. Attendees there appeared to be bored with long periods of downtime when not performing the assigned tasks, which were monotonous and or mundane. There seemed to be little interaction among attendees. Before these 3 visits, my husband and I were ready to sign on the dotted line and send her to a 14C entity, which would achieve our goal of finding a structure to Monica's post-school days away from home. In the end, we followed not only our own impressions, but more importantly, Monica's vehement objections to her attending a sheltered workshop. Out of desperation, Monica applied to and was accepted to our county vocational technical school, and which granted her a certificate in retail food marketing after 2 years. Upon graduation, she was offered a part-time job at a grocery store, and later on applied and received part-time position at a new Costco warehouse, and eventually was asked to become a full-time worker at another warehouse. Monica's road to full-time employment and a decent living wage with paid time off, health, and other benefits was winding with many bumps and some barriers. Her employment success is an outcome of her strong desire to work, her own work ethics, and the employment and other supports received, all in integrated settings. The interactions Monica has with co-workers and customers have been the best rehabilitation she's received at no direct cost to her or to the public. Her ability to recall information and to respond appropriately has improved since exiting her educational entitlement. In my opinion, a number of Monica's disabled friends in 14C entities not only want to hold competitive integrated jobs, but also have the attributes necessary to do so, if only they would be given access to effective job support, reasonable accommodations, and the opportunities to acquire skill. Research indicates that those who had previously been in sheltered workshops had higher support costs and lower wages than comparable people who had never been in sheltered workshop settings. And we've had a number of research results which would support this statement already. From Monica's own experience in high school, I know that an individual's behavior and performance are partly impacted by the setting and the implicit or explicit expectations of the environment. Supervisors of workers with disabilities in sheltered workshops evaluate the performance of these workers in restricted and confined contexts. As a result, participants in sheltered workshops are viewed by their supervisors as not being capable of working outside the strict confines of these workshops.
Can you bring your comments to a conclusion? We've passed time.
Thank you. Disability employment has been regarded as the next frontier to empower people with disabilities to live full and independent lives. The Transformation Act would build capacity, improve the disability employment service, and
sorry, ma'am, we are.
Thank you.
Okay, thank you very much. We do have your full testimony, and that will benefit the committee. Thank you very much. We'll now hear from Mr. Anton. Mr. Anton, you have 5 minutes, sir.
I recognize her.
Okay, all set. Good morning.
Good morning.
Good morning.
Okay, they can hear you. Go ahead.
Good morning.
Thank you for inviting me to speak today. Growing up in segregated and devalued and hard to use my voice, I felt invisible and not respected. My parents helped me to be included in Special Olympics, Boy Scouts, hunting and fishing with my dad, After high school, I did a variety of food service jobs, which were not good for my diet, I can tell you that. Then I attended the local workshop doing jobs such as packaging, shipping, and piecework. It was very boring. My friends would be playing cards, watching videos, and just hang out with nothing to work on. In addition, I got paid for very little. It was discouraging, and I did not encourage us to do our best. Many of my friends felt the same way. One friend worked for the week of $1.25, and another friend paid only $10 a week for cleaning bathrooms. But I went to my supervisor and said, I want to do more. He told me no. And look, so I quit. The local ARC helped me to learn how to dress professionally. I wanted a job wearing a suit and tie and carrying a briefcase like my dad, who was my teacher. I have learned the legislative advocacy can make things happen. I led the Mass Advocates Standing Strong regionally, and I went on to be the chairperson for the statewide organization, and it's all about respect and dignity as a citizen. For me, it's not being stigmatized on labels which belong on jars, not people. I was hired in Massachusetts Down Syndrome Congress as a legislative specialist. I got paid for the minimum wage, and I advocate for legislation and supports and protects the rights of all people with Down syndrome. For many years, I also have worked as a legislative intern at the State House in Boston on bills affecting all of us. Many self-advocates, and I come to Washington, D.C. for the National Down Syndrome Society. We advocate for policies to ensure that all people with Down syndrome have access, meaningful jobs, health care, and other important resources. The NDSS has connected me a 5-week internship with the Congresswoman Kathy McMorris Rogers from Washington State, who has a son with Down syndrome and is a co-lead on HR 2373. And I am proud to be here today to represent both the organizations with the Mass Down Syndrome Congress and the NDSS. For many years, people told me that I could not do what I wanted, but I persisted. My parents were so surprised in how high my goals were. Look at me now. The fact that people with disabilities need real jobs for real pay. Like all of you, I urge members of the committee to support and phase out the 14C and the transformation of the Competitive Integrated Employment Act, HR 2373. Thank you.
And thank you very much. Right on time. You did a fantastic job, sir, and you look good too. So, Dr. Putz, we now recognize you for 5 minutes, sir.
Good morning. Thank you, Chairs Adams and Bonamici, Ranking Members Keller and McLean, and members of the subcommittees for the invitation to provide this statement regarding 14C wages as discussed in the Transformation to Competitive Integrated Employment Act. Employment Horizons, founded in 1957, is a nonprofit community rehabilitation program, or CRP, in Northern New Jersey. Our program participants, the people with disabilities we serve, participate in a wide range of programs, which include supported employment, work on janitorial, groundskeeping, and fulfillment contracts, and a variety of other vocational programs. While Employment Horizons is proud of the work we do to ensure employment opportunities for individuals with disabilities, we are just one organization out of thousands nationally that provide these life-changing services. In order to ensure that as many people with disabilities as possible can work, CRPs rely on a variety of methods and tools, including in some cases, 14C special wage certificates. Elimination of 14C certificates as proposed in HR 2373 would eliminate employment opportunities for thousands of employees who want to be able to choose the type of employment that makes the most sense for them. In fact, the outright elimination of 14C certificates benefits no one. Those working under 14C certificates already have the right and option to pursue competitive integrated employment. They also have the right and option to pursue non-vocational programs like day programs. Employment within a 14C program is just one of the many choices available to people with disabilities who wish to work, and only one type of program offered by CRPs. Part of my role is to advocate for the rights of people with disabilities. It is crucial that I raise awareness about any issue in which a person with a disability loses the right for self-determination or the right to make choices about their own life. The elimination of 14C certificates does just that. Such a step assumes that people with disabilities cannot make their own best choices about the type of employment and setting they would like to work or spend time in. Discontinuing 14C programming also makes the assumption that working with people without disabilities is somehow innately better than working in a setting with people with disabilities. How can we assume and apply a standard that work is only valuable when performed around a preponderance of non-disabled coworkers if we truly believe in the value of people with disabilities? If we accept the basic premises that people with disabilities are valuable members of our community and that they have the right to self-determination, then we must also accept that they have a right to a full array of employment and program options. Why then would anyone argue for the elimination of 14C? Often those who would like to see 14C eliminated are not fully aware of the value of these programs or have been provided information on them that is not fully accurate, including some of the following misconceptions. First, many people believe that 14C certificate holders receive a financial benefit through having such a certificate. Second, some people believe that employees in 14C programs are unaware of other employment opportunities or are not provided alternatives. And third, a common misconception is that the closure of 14C programs would result in more people with significant disabilities working in competitive integrated employment. The use of 14C certificates as part of a continuum of opportunities for people with disabilities is a complicated issue. Unfortunately, grant funding and elimination of such certificates are not enough to ensure a transition from 14C to competitive integrated employment. More research is needed on the impact such elimination would have, and employers must be part of the conversation as competitive integrated employment relies on their hiring decisions. Ultimately, the self-determination of people with disabilities must be preserved. I leave you with the story of a former program participant working under a 14C certificate. This individual started working in a 14C program after high school. After developing the necessary skills, she transitioned into competitive integrated employment, working in the hospitality field. As part of her disability, she had a number of medical issues, including frequent seizures. As these conditions worsened and her seizures became more frequent, she left competitive integrated employment and returned to her earlier 14C covered job, where she continued to work until unfortunately passing away in her 50s. There was not a day in either of her jobs where she was not proud to be working. However, without the full continuum of services available to her, she would have needed to stop working as her seizures worsened and may have never achieved her earlier competitive position. Her 14C employment allowed her to both develop critical work skills initially and to finish her career in a safe and supportive setting. I appreciate the opportunity to speak to you about the important issue of 14C employment and the array of employment opportunities available to individuals with disabilities. I look forward to continuing the discussion and believe that together we can find creative ways to ensure the best and best paying employment possible for people with disabilities. Thank you.
Thank you, Dr. Putz. Now we'll hear from Mr. Lewis. You're recognized, sir, for 5 minutes.
Good morning. Can you hear me okay?
Yes.
I'd like to offer, I'm blind, so I cannot see the timer. So if someone would just say 2 minutes at 2 minutes left and 1 minute and 1 minute left, I'll adhere to the time constraints.
Okay.
So My name is Anil Lewis. I live in Atlanta, Georgia. As stated, I am the Executive Director of Blindness Initiatives for the National Federation of the Blind, which is an organization of blind people that realize that blindness is not the characteristic that defines you or your future. See, every day we raise expectations for blind people because we realize it's those low expectations, like those that are perpetuated through Section 14C, that create the true obstacles between blind people and our dreams. And we recognize that you can live the life you want. Blindness is not what holds you back. And this is true, we found, for other organizations as well. I appreciate this opportunity to testify before the committee. I hope that I'm able to convey the message that I like, because I have a history in all of this. And if you do take the time to read my written testimony, you'll see, especially I appended the testimony that I was able to give at the United States Commission on Civil Rights, which talks about how Section 14C adversely affected the future of my brother, created a tremendous amount of guilt on behalf of my mother, created tremendous barriers for employment for my sister and myself. But I'm trying not to emote around that issue because I have come through the fog and understand that there's a better outcome. But in all honesty, in evaluating all of this, I had to realize that as a professional early on in my awareness around disability and the capacity of people with disabilities, I also helped support a subminimum wage workshop at a community rehabilitation program. So I have true empathy and understanding, lest I be a hypocrite, for those who still feel like that antiquated remedy is still the solution for people with disabilities. Working with the National Federation of the Blind National Office in 2011, I was a legislative lead in trying to pass legislation that would eliminate 14C. I have to admit, and upon reflection, the strategy that we described in our legislation, the proposed legislation then, was woefully inadequate. The legislation before you now has addressed, in my opinion, all the concerns that existed on both sides. But it's only important if we understand that those who support 14C, I've come to know, are not committed to the exploitation and the discrimination that I have to admit back in 2011 was the messaging I put out there. There are individuals through there, what I understand is misguided compassion, which I had as well, are well-intended and have just really been invested in a philosophy that, again, is antiquated. I could take the time to express all of the data, but data tends to take us off message because we can contest numbers, but it doesn't get us to the place where we can change the minds of people. And we start by actually informing the heart. When I was doing this work under Sheltered Workshop, thought that I was doing God's work.
You have
in my
2
testimony,
minutes, sir. You have.
I thank God for I thank God for those who continue to show me that it is possible. And I think that the written testimony is there, but I'd like to take this opportunity based on the scenario that was just described to give you an alternate perspective. So you have an individual with a significant disability that's employed in a sheltered workshop. And she was able to obtain competitive integrated employment, which I think speaks to the fact that many individuals who given the opportunity would choose competitive integrated employment. It's not fair to say that every individual in those sheltered workshops has that opportunity. Went into that environment, but then due to medical reasons, as explained, chose to go back to the sheltered workshop environment. Okay, so let's yield and say that was a choice. But I think that we're making the assumption that the services that we're aspiring should be provided in that instance to support her in that competitive work environment, which could have made
1 minute, sir.
Equally possible for her to do so. We're done. And I don't think that's the case. But even more so, I'd like to stress the difference of this. Eliminating 14C is not closing the shops. We already see shops that have been eliminating 14C and still able to continue to operate. We need to understand that the ability for people to work competitively in these environments does not depend on the wages. That's the employer's decision. It's not going to close the shops. It's not going to eliminate choice. And it doesn't do the things that many of the things were described, but I understand the value and the motivation for doing so. I just recognize that the Transformation Act puts the technical assistance in place that I think is necessary, the grants that in place that will make it possible, and really shapes in a way the paradigm for us to seek better futures for people with disabilities, not acquiesce to the antiquated philosophy that existed. Thank you for your time.
And thank you very much, Mr. Lewis. We appreciate that very much. Under Committee Rule 9A, we will now question witnesses under the 5-minute rule. As this is a joint committee hearing, after the chairs and ranking members, I will be recognizing subcommittee members based on seniority order on the full committee. As chair, I now recognize myself for 5 minutes. Mr. Lewis, a March 2021 Government Accountability Office report described the consequences of the COVID-19 pandemic for the employment of people with disabilities. For example, the pandemic made congregate work settings more dangerous, made it harder for disabled people to get jobs. In your view, sir, what has been the impact of the pandemic on efforts to transition people with disabilities into competitive integrated employment? And what role can the Transformation to Competitive Integrated Employment Act play in helping to address the challenges?
Sure. I mean, there were so many negatives and actually positives that resulted out of the pandemic for people with disabilities. Yeah, based on the nature of the shelter workshop model, the congregated environment did create a problem for the virus spread. It could turn into super spreader locations. But many individuals who were, again, in competitive integrated work environments were not adversely affected by that particular scenario, but they were adversely affected by the fact that many of the accommodations that were needed in order for them to be employed had to be adjusted and improved on. So I think in a strange way, the things that we learned, the strategies that we learned to support those individuals that were already in competitive integrated environments are strategies and tools that we can use now to enhance that employment post-pandemic and also create opportunities for more individuals in those sheltered congregated environments to transform and transition into competitive integrated workplaces.
Okay, great. Mr. Lewis, in his testimony, Dr. Putz cited a study finding that after Maine eliminated 14C employment, the number of people with disabilities employed in the state decreased, as did their work hours. Dr. Putz cited the study as evidence that phasing out 14C would be harmful to people with disabilities. So if you're familiar with the study, can you put its methodology and findings into context for us? Do you, for example, consider the findings valid? And if not, why?
So again, as I stated, we could look at data and analyze data. This specific study, I received information that did challenge the validity of the data. But I'd like to take this opportunity to make the point. Even if the data was correct, again, we're operating under assumptions that the processes that we're ascribing now were followed. And I don't think that that's the case. It's been demonstrated across the country that entities who use the strategies that have been developed to actually transform their business model to transition into this new integrated model are successful. So to state that it happened as described in the data provided in Maine is probably more of a confirmation that it wasn't done correctly or using best practices.
Okay, at the time of publication, wasn't the study's validity refuted due to the problematic research design, the very low sample size used, and the conflict of interest of the study's funder?
Correct, and that's where I saw one of the data analysts who evaluated the study also shared those same results with me. But again, I could pull data that shows in other states how it was done correctly and created the positive outcomes that we aspire to achieve.
Thank you. So beyond this one study, what do research findings more broadly tell us about the outcomes for people with disabilities when states have eliminated the 14C employment? And I just have a minute left.
Sure, overwhelmingly, the data shows that individuals in those states that have done it correctly, that have used not only the opportunity to provide employment, the support, but also the wraparound services that are necessary, have proven to have an increase in the employability of people with disabilities in competitive integrated work environments.
Okay, well, thank you, sir. Thank you very much for that. I want to now recognize the ranking member of the Ed and Labor Committee, Dr. Fox. I'm going to recognize you if you will take 5 minutes. You are recognized, ma'am.
Thank you, Dr. Adams, and I want to thank our witnesses for being here today. Dr. Putz, thank you for your testimony and for making it your life's work to offer employment opportunities to people with disabilities. We've heard some strong rhetoric already about 14C employment opportunities and the people who provide them. That rhetoric doesn't seem to match what we've heard from you. Could you just tell us more about yourself, how you got into this work, and what motivates you?
Sure, thank you. So my first job out of college was actually as an employment specialist at Employment Horizons, where I am still employed. I was working with individuals with physical disabilities and brain injury, helping them find competitive integrated employment, and very quickly fell in love with the field in terms of helping individuals with disabilities become more self-sufficient by finding and keeping jobs, and learned an awful lot about the meaning and dignity of a job and how much that goes beyond just a paycheck. After a pretty short period of time in the field, I realized I really couldn't see myself doing anything else, and continued my education in order to be able to do more in the field, earning a master's in rehabilitation counseling and eventually a PhD in rehabilitation counseling and administration, and working my way through different administrative positions until eventually becoming CEO of Employment Horizons in 2016. Beyond my work at Employment Horizons, I'm involved in a number of different government and board type of roles. So I am the chair of the board for Access New Jersey, which is our trade association here in New Jersey. Serve on a paratransit transportation committee to ensure transportation options for folks with disabilities. And I'm also on our Tri-County Workforce Development Board.
Thank you. Dr. Putz, as we like to say in this committee, states are the laboratories of innovation, sometimes for the better, but sometimes for the worse. We think Congress can learn a lot from what states are doing to create opportunities for individuals with disabilities and to find out which policies work and which do not. In your testimony, you discussed one state that stopped the use of 14C certificates. Could you please expand on the outcomes of that decision for individuals with disabilities and how this experience should inform the debate about the 14C program at the federal level? And let me add very quickly that I'm a firm believer that there is tremendous dignity in work for every single person. And I will put something in the record about this after the hearing today, but please go ahead and expand on the outcomes.
Absolutely. So the state that I referenced was Maine, which was spoken about just a minute ago. And the report was put together by George Washington University. In 2011, which was about 3 years after the transition in Maine, people with intellectual disabilities were working an average 12 hours a week, which at the time was the lowest in the nation. And that was a jump from an average of working over 4 days a week before the closure of workshops to working less than half a day a week after. Following the closure of 14C programs, it was found that people with disabilities were spending more time in community support activities than they were before the transition, which means non-work activities. And the employment rate of people with disabilities actually decreased from over 39% to about 34%, which was greater than the work for non-disabled individuals during that same time period. By 2010, in fact, integrated employment had decreased from 31% to 23% for individuals with intellectual and developmental disabilities, and participation had increased for non-work facility-based services. So folks were still coming to nonprofit organizations, but they were doing non-work activities. And so while individuals were earning more per hour after the transition, they were earning less in total due to the decreased number of hours that they were working. So my biggest takeaway from what happened in Maine is that Maine planned for this transition and still got this result. And they're a relatively small state with a relatively small number of people that needed to be transitioned out of 14C. According to the GAO report, we could be looking at as many as 125,000 individuals working under 14C nationally. And if a small state with time to plan the transition couldn't pull that off, then I'm very concerned about what that would mean nationally.
All right.
Thank you. Madam Chair, I believe I have 14 seconds left. And what I want to say is we'll be asking you a question after the hearing that we'd like to put into the record about your experience with the issue on determining on a case-by-case basis the competitive integration employment determination. And with that, I yield back.
Thank you very much. I appreciate that. So now we'll hear from Ms. Bonamici, Chair Bonamici.
Thank you so much, Chair Adams, and thank you to the witnesses for being with us today. I want to start with Ms. Kopstein. Thank you for sharing the story that your family experienced, and I wanted to ask you, the Transformation to Competitive Integrated Employment Act would strengthen wraparound support services to help workers with disabilities transition to competitive integrated employment. So could you talk a little bit about what support services and benefits, or the wraparound support services and benefits, were most important for your daughter Monica's success and integration into the workplace?
Yes, thank you for the question. In fact, the wraparound services that Monica has received, funded by the Division of Developmental Disabilities, has provided her with not just a supplement to her workday, which started off as part-time, but also provided her with some control over her own day and schedules and activities. She has used this funding and services to participate as a member in a local gym that has helped her learn the benefits of exercise, healthy eating to keep her weight down, and also has learned skills that would help her prevent injury at work and at home. Simple work skill. Everything has to be taught to Monica. For instance, how to lift a heavy object from the floor. I suppose I could benefit from that as well. So in addition, she has also used opportunities that were not funded publicly outside of her services. So it has really enriched her life and supplemented her day of work in very meaningful way, while exposing her to and providing her with network of friends outside of her usual special education. Not that they are better or worse, but just different exposures actually help people grow.
Right, thank you. And is it fair to say that she wouldn't have been as successful without those wraparound services?
Absolutely, they are crucial, and I'm glad that the Transformation Act has been so insightful to provide this wraparound services, which are so crucial in many ways.
And I want to move on to Mr. Lewis. Mr. Lewis, in your testimony, you noted that you testified before the U.S. Commission on Civil Rights about the importance of helping people with disabilities transition into competitive integrated employment. And thank you for that involvement. I know your voice matters. So can you underscore for us why phasing out the 14C subminimum wage is a civil rights issue? And also, what is the nexus between 14C subminimum wage and the Americans with Disabilities Act and the Supreme Court's decision in Olmstead?
Yeah, and I think that's a really important question. So I'll focus the answer on that. In all the discussion, I think that we're convoluting the issue. 14C itself is what's counter to the Americans with Disabilities Act, which states that people with disabilities have the same rights as any other American citizen. 14C is a provision that allows people with disabilities, just for the fact of having a disability, to be paid less than everyone else. In many instances, it's not because the people with disabilities lack the capacity, it's because the professionals who work with them don't evolve into a place where they recognize there are evolving new strategies to do so. I was one of those people, so I recognize that that's the case. The Olmstead Act really shows that by integrating and working to integrate people with disabilities within the community, not only does it create quality of life for people with disabilities, but it also reduces the public burden. The data's out there, it shows it, but we're not going to be able to move further until we get people who, again, through that misguided compassion, remain vested in that old antiquated philosophy around the incapacity and the low expectations. We got to shift the paradigm.
Thank you, Mr. Lewis. And I agree. I really see this as a civil rights issue. And to say that there's a category of people who don't deserve to earn minimum wages is just, to me, an injustice. So I'm glad that we heard from you today, as well as our other witnesses. The personal stories really do make a difference as we move forward with this important legislation. Thank you, Madam Chair, and I yield back.
Okay. And thank you very much, Chair Bonamici. And looks like it's Mr. Keller.
Thank you, Madam Chair. Thank you. Dr. Putz, members of both sides of the aisle share the goal of ensuring that individuals with disabilities have employment opportunities. According to the Bureau of Labor Statistics, less than 20% of individuals with disabilities were employed in 2019 and 2020. By comparison, almost 62% of individuals without a disability were employed in 2020. In your experience, would ending this Section 14C certificate program as required by HR 2373 actually improve the employment rate for individuals with disabilities or help address this disparity?
Thank you. So from what I have seen from the data and from my personal and professional experience, I believe that ending 14C would actually decrease employment opportunities for people with disabilities. As you pointed out, unfortunately, employment rates for people with disabilities are dismally low and have been that way for as long as any of us can remember. Those working under 14C certificates are typically the individuals with the most significant disabilities. And so there's little reason to believe that ending 14C would in that case improve employment rates when what we've seen on a large scale is that the systems that exist are unsuccessful at that. And so I am deeply concerned that if 14C were to go away without some sort of replacement, that we would be looking at significantly decreased rates of employment for people with disabilities. And you can see that in places where 14C has ended, that there's a lot more engagement in non-work activities.
You mentioned non-work activities, and an individual that is going to a non-work activity, and I imagine they get some kind of help with life skills and education on being able to get a job or have employment. Do they get paid any money for going to these non-work activities? Do they earn any money while they're in non-work activities?
They do not. And so from my perspective, that's where 14C comes in, is that those same work skills, that same career counseling, the developing the ability to work through a full workday, et cetera, can be accomplished in a 14C setting where actual work is being performed for real companies, a paycheck is being earned, and folks get the dignity of reporting to work, of going to a job, as opposed to, you certainly can acquire some of those skills in a non-work setting, but I don't believe that's the same and has the same value, unless someone chooses that as going to work does.
So in order to get the skills and employment experience necessary in an environment with 14C would be the equivalent of a high school student getting their first job and learning their job and learning the work environment and so on. Meanwhile, people in the 14C certificate program are earning a few dollars while they're doing that.
And to be clear, that 14C is commensurate wage. And so there are folks that are earning more than a few dollars when we talk about this. There are folks that are actually making above minimum wage, but below a contract or prevailing wage. And people with working in 14C settings, and everyone with a disability, has their own unique needs. And so the setting that's most appropriate for one person is the setting that's most appropriate for that one person. If you've met somebody with a disability, that's all you've done is meet one person with a disability. And so it's really important to maintain the full array of options so that folks for whom 14C is an appropriate choice have it. And other folks certainly, can choose other things. And we're proud at Employment Horizons to provide that full array.
Thank you. And actually, you're 100% correct on individuals that have, and I like to refer to it as different abilities. Everybody has abilities. And my wife actually worked in the Commonwealth of Pennsylvania for 34 and a half years in a setting where she worked with individuals that had disabilities. And actually, the job I had in the factory I managed, we hired people with job coaches to help give them the experience they need. We didn't have 14C certificate. We we paid the wages, and depending upon the job we could do that. Individuals with disabilities have disparate and unique needs. In your testimony, you discussed the menu of services Employment Horizons offers to meet employment-based needs. Can you discuss further what role the 14C certificate program plays in providing options to individuals with disabilities?
The 14C certificate just allows for a wider array of options. So without it, we would be sort of left with the extremes of supported employment in a competitive setting and those pre-employment and non-work sort of opportunities. And so with the 14C, there's something in between that for the folks for whom that's appropriate. And that could be learning soft skills. It's developing the stamina and the concentration needed for a work day. It allows those with safety or behavior challenges to work rather than attend non-work programs if they choose. Many folks with intellectual and developmental disabilities receive relatively few hours of CIE. And so some individuals then can actually split their time between competitive opportunities and work in a 14C program.
Okay, we're out of time. Okay, thank you very much. Appreciate it. I'll now recognize Mr. Takano. Mr. Takano, you have 5 minutes, sir.
Thank you, Madam Chair. My questions are for Mr. Lewis. Mr. Lewis, as you described in your written testimony, you previously managed a sheltered workshop that employed people who were blind, but it successfully transitioned virtually all of these workers into competitive integrated employment. Can you tell the committee what the key factors or practices that helped these individuals transition to competitive integrated employment?
Sure. The key factor was in my paradigm shift. I was looking at them, even though I was a blind person, society made me feel like I was an exception because I was doing other things that other blind people were not. And I'm not the exception, only because the systems in place make it the exception and not the rule. But I saw them as individuals, handicapped individuals, less fortunate than me. Once I realized that they were just people with disabilities with the same rights and aspirations that I had, and I got access to the tools that the National Federation of the Blind provided with respect to work incentives for Social Security, different alternative job modifications and strategies. Again, I didn't know all of this. I was operating from a limited knowledge. Once I started implementing those and then empowering them, because the other thing I had to do was take an institutionalized group of people who had been in that workshop for years, who had made that comfortable for them, and that was what they did day to day, recognize that there was another alternative, and to give them a real understanding of what that opportunity consisted of, that it wasn't just wonderful, but with a lot of work, it could create a better outcome for them. So working collaboratively on myself and implementing the strategies to work with the consumers, we were able to get those individuals competitively employed. And I must say that was done in, I guess I would at this point say haphazard, because the Transformation Act itself really prescribes what should have been done. And if we would have had the funding through the grants and the technical assistance that's provided, I would have been able to do a much better job.
Well, Mr. Lewis, what were the practices? Can you just sort of enumerate the practices that help these individuals?
Yes. So one of the things that was just mentioned was the term non-work. So yeah, we bought into the fact that they were earning some money and acquiring a skill set, but the skill set they were requiring were how to fold and stuff envelopes. And that wasn't going to be a gainful opportunity for them to be employed. So what we did was we had them participate in non-work. And I'll just offer this as an understanding. I participated in non-work. It was called college. I didn't get paid. As a matter of fact, I got in debt as opposed to it. I wasn't paid for it, but it allowed me to acquire a skill set and the knowledge to become competitively employed. So that's what we did. We stopped paying them subminimum wage for doing work that wasn't leading to a successful outcome, and using that time through our nonprofit status to raise money, capitalizing on other public programs that paid for this type of assistance, and provided them actual training in a skill that resulted in competitive integrated employment. So non-work is not a bad thing. Non-work is what we all participate in as we acquire skill set and talent to become employed.
So really what you mean by non-work was training that led to some sort of skill that would lead them to employment, full employment, not sub-minimum wage employment.
Exactly.
So really what we call non-work is really some sort of training or broader education.
If we do it right, again, if individuals who aren't really vested in a successful outcome, yeah, their answer is going to be, well, if we can't pay them some minimum wage, well, I guess we'll just let them sit there. And like the other witness said, playing games. Of course, they're having fun. And many parents think that's great because their kids are doing something, but they truly don't recognize that there is an alternative that leads to a better outcome for their children. I also reference a conversation I had with a parent of a child with significant disability, who I know through my experience, I would have been able to help them obtain competitive integrated employment. But because she had been told by professionals year after year after year that the best her son could do is work in that skilled workshop.
Mr. Lewis, with the time I have remaining, that one example of the intellectual disability, that one person, what competitive work did they obtain?
She told me, and it was really just interesting. Again, I didn't get to work with him because she didn't want to work with me. But she, in her discussion with me, told me that in the times when he wasn't at the shelter workshop, he actually worked at their local church. And she described him doing a variety of different custodial jobs. That's a no-brainer. I wouldn't want to relegate him to just doing that, but I knew at a minimum that floor was he could have obtained a competitive wage in any other environment doing custodial work.
All right, well, thank you, Madam Chair. I yield back.
Thank you so much. Thank you so much. Now, Ms. McLean, you're recognized for 5 minutes.
Thank you, Madam Chair. Mr. Putz, you talked in your statement about the dignity of work. And I agree with you on that. The principle was especially evident in the moving story you talked about, the former participant in your program. I think everyone would agree we want to provide an environment that enables people with disabilities to flourish, and also to get as many of those people with disabilities involved in that process through listening. That's what I hear we all agree upon. However, I think the injustice would be if we decreased the amount of people that we could get into that program, in those types of programs. And I think by eliminating this, that is what we're doing, or at least that's what the facts tell us. And although I would love to live in a world where facts didn't matter and we could just go on about our day with our feelings, that's not reality. And I think it's my job to really get us into reality and pay attention to the facts. That's what I'm here to do, and that's what I'm here to try to understand. So the facts tell me that if we eliminate the 14C program, that we would in essence have less people in these programs, which is counterintuitive to what we're trying to do. The other thing that I want to point out is, as a business owner, we're not taking into account the actual people and entities that employ these people, which are the businesses. My fear is that if you take this away and you mandate to a business what they need to pay, they do have a choice and they do have an option. So one of the things I would like to suggest is, instead of mandating, why don't we incentivize them? That would seem like a lot better idea, to be more inclusive, and we can broaden the tent. But the piece we're forgetting here is that the business actually has a choice as well. So I would offer a suggestion that we be inclusive to the businesses and that we incentivize the businesses as opposed to mandating them. With that said, why, Mr. Putz, why is access to a job so meaningful to people with disabilities? And what is the impact on those people's dignity when employment opportunities are taken away? Because the facts actually show, not the feelings, but the facts actually show that if we eliminate this, we are going to employ less people with disabilities. and those opportunities are going to be taken away. So can you share with me what the impacts of that dignity would be when the opportunities are taken away?
Sure, and I think you're right in that a lot of what we're hearing doesn't put the onus on the businesses where it falls. And we can see that already it's not that there is a lack of access to people with disabilities on the job market. The majority of them are unemployed. Employers are not making the decisions to hire them. And so there does need to be focus on the employers. Many folks that are non-disabled take having a job for granted. And it's how a lot of non-disabled folks actually identify. It's one of the first things we ask someone when we meet someone new is, what do you do? And for folks with disabilities, a lot of the times there isn't an answer for that. And so it is about the dignity. It's the sense of the sense of purpose. It's a reason to get out of bed in the morning and have a place that you report where you can be proud of the work that you're doing, and you can connect to other people. How many of us, our daily connections, the social interactions we have take place at work? And I can tell you exactly what the loss of that opportunity looks like, because in New Jersey, all of our 14C programs, all of our workshop programs were shut down for over 7 months because of the COVID-19 pandemic by the state. And I can't even tell you the heart-wrenching Facebook messages we were getting, the emails we were getting, the phone calls we were getting from folks that went from having a place that they went daily to work to not having that and not knowing if we were going to reopen ever or when that would be. And it really was gut-wrenching to see.
And what I understand, and I want to make sure I understand this correctly, from your data, if we eliminated this 14C program, we would have less people with the opportunity to work. Did I hear that? Is that simply put?
Correct. We would have, there certainly would be some folks that would leave 14C for competitive integrated employment, but what we've seen is it's not the majority.
And that's not our goal. I don't think that's anyone's goal. But the policies would have some unintended consequences that would work in reverse to what we're trying to accomplish. Thank you. Thank you, ma'am.
Thank you. Okay, next, Representative Hayes, you're recognized for 5 minutes, ma'am.
Thank you, Madam Chair. And thank you to the witnesses who are here today for being with us. The phasing out of 14C is not only a labor equity issue, it's a civil rights issue. Every worker, including workers with disabilities or differing abilities, deserve a living wage. This issue is somewhat personal for me. I worked at Southbury Training School, a residential facility here in Connecticut, in my state of Connecticut, for people with physical and intellectual disabilities. I was there for 15 years, and I have been a job coach and supported so many of our residents as they worked at these sheltered workplaces. Through those years, I experienced firsthand that while many of those individuals required specialized services, I also saw the potential for them to succeed with proper supports and saw many of them thrive outside of those workplaces. Another concern that I saw is that one of the workshops that I was in was a place where the employer asked, the job was to piece together packets for a much larger corporation. Those packets were sold at full price, while the people who put them together were paid a sub-minimum wage. I've heard concerns that the passage of the Transformation to Competitive Employment Act would mean an end to sheltered workshops nationwide. I just do not believe that to be true. So, Mr. Lewis, can you describe the resources provided by the bill for employers to transition from utilizing 14C certificates to providing high wage employment for all workers, including workers with different abilities?
Thank you for this question, because again, I think that's the point that needs to be hammered home. The phase out of 14C is not going to eliminate the ability for these existing community rehabilitation programs to operate. Those entities that say that they can't, that's a business decision that they're making because their peers in this environment are doing it and doing it successfully. The Transformation Act itself has provisions that, again, I wish were in place back when I was doing this. There are grants to the states that want to implement the services. to allow the workshops to transition into a new business model, a new proven business model. And we know that in instances where the states are not willing to apply for the grants, there's still going to be some ambitious community rehabilitation programs that recognize that this is the right thing to do. And the bill itself offers grants for those particular entities to do it as well, which is a great thing because they will become exemplars, right, for their peers. And then it also offers technical assistance. Again, building on the best practice of what's been done makes it possible for others to do it without the overhead that it costs. I would bring another example. When we first started advocating for the phase out, well, we've been doing it as an organization for centuries, well, not centuries, decades. But when we, in this recent initiative started, we were engaging with the individuals at Goodwill Industries, which had a significant amount of their community rehabilitation programs dependent on 14C. And I remember a conversation with Jen Gibbons, who was the executive director at the time, and we pointed out that approximately 2/3 of them were working without the 14C certificate. And we were asking, and I never got to answer this question, so the 1/3 of remaining community rehabilitation programs that say that the 14C certificate is needed, so what is that? Are they dealing with a more significantly disabled population than the others, which was not true? Or the people in their geographic area somewhat more disabled than others, which also wasn't true. The fact remains that it's been proven by a majority of entities that it can be done. And the decision not to do so is a business decision, not a result of the incapacity of the people with disabilities.
Thank you. I appreciate that because in my district, there are two businesses that I can think of off the top of my head that are very successful. One of them is a cafe and the other is a movie theater that is fully staffed with people with differing abilities, and they are a thriving business. With the remainder of my time, I want to go to Mr. Anton. You talked about actually going to your supervisor and quitting your job because you didn't feel that you were fulfilled. How difficult was it for you to find a new job after you made that really important decision? Mr. Anton?
Say hello.
Hello.
Hi, I'm sorry. I don't know if you heard my question. I said, when you made the decision to quit your job, how difficult was it for you to find a new job?
It took me a while to figure it out from the beginning.
Mm-hmm.
But and I also, and through my advocacy, work people saw me working hard to get hired at MDSC, the Mass Down Syndrome Congress, as a legislative specialist, and also the minimum wage, above the minimum wage. And thank you.
Okay.
Thank you, Mr. Anton. You show us that it is in fact possible. Madam Chair, I yield back.
And thank you very much. Mr. Thompson? Mr. Thompson on the platform? Okay, then we'll go to Representative Miller Meeks. You recognize 5 minutes.
Thank you, Madam Chair, and I want to thank all of those who are providing testimony today. I have a best friend whose daughter has an intellectual handicap, if you will, but I also have experience with an organization in my hometown, TINCO, who does assist and help individuals with disabilities of all kinds. And when the state of Iowa was raising the minimum wage, ended up having individuals who lost employment. We also had a situation where, unfortunately, there was an abusive situation and employment was terminated, but those individuals to this day have not been reemployed, those with disabilities, and are now leading a much less functional and engaged life than they were. And they've commented upon this to us. So I think Mr. Putz, last Congress, this committee held a hearing where one of the witnesses testified about his organization's transition away from the use of 14C certificates. Prior to the transition, his organization employed 500 workers using 14C certificates. After the transition, the organization was only able to employ 65 individuals with disabilities at or above the minimum wage. where the average employees were working part-time. While about 1/5 of these workers were able to find competitive employment outside the organization, this circumstance strikes me as far from being an unqualified success, and certainly it would mirror my understanding of what happened in my own hometown of 26,000 people. So Dr. Putz, based on your experience, would HR 2373 lead to similar outcomes, including fewer hours worked and employment opportunities for individuals with disabilities? And would not companies hire people at higher wages and then make a task that they had someone else do, make that part of the expanded tasks that an individual with a higher wage would do?
Thank you. So sadly, I'm not surprised by that result. I believe you'd see a very similar result on a broad scale, a concerningly broad scale, if not a worse overall result, due to the lack of resources for a much larger population. So it's one thing to scale down 14C for a particular organization, but to do it nationally, again, for 125,000 or so people, is quite the undertaking. And so while I wasn't present for that testimony, the evidence in general suggests that the 1/5 who got jobs were likely working fewer hours ultimately and earning less money overall, even though their hourly wage may have increased. And as minimum wages continue to go up, there really aren't as many jobs with one or two sort of tasks that exist anymore. And for individuals with intellectual and developmental disabilities, it does get harder to place individuals into those jobs because there's so much more complication and multitasking involved in that. So there has to be incentive for employers to carve out positions that make sense as appropriate. And that's, again, not an easy thing to do because there are millions of employers and they're all independent entities. And so that's a bit of an undertaking.
And Dr. Putz, can companies or businesses or nonprofit, other organizations, can they continue to work on increasing the job skills of individuals with disability while they're engaged in employment with the 14C certificate?
Absolutely. And we do have folks actually working in our workshop downstairs right now who split their time between competitive integrated employment and 14C. They're developing job skills in both of those locations. And we flex their schedule here in order to match the schedule that they have at the employer because we give that precedence, but it's absolutely possible to do both and to continue to develop really important skills from both.
So that looking at the individual as not just having a static set of skills, but skills that would be dynamic as we would see in any employee in any workplace.
Sure, and I think one informs the other.
Great. Thank you so much for your testimony. Madam Chair, I yield my time.
Well, thank you very much. We want to recognize now Representative John Hall. You have 5 minutes, ma'am.
Thank you, Madam Chair. Thank you very much for holding this hearing on phasing out the subminimum wage. I think it's just important, again, to ground ourselves in the stories of how people with disabilities get compensated under the subminimum wage that is so disturbing. And so just a couple I want to highlight. A man in my home state of Washington worked 6 hours a day only to make $70 every 2 weeks. Another individual earned $1.54 an hour, even while producing 2 times the number of products compared to their supervisor, who made over $100,000 a year. In New York, workers with disabilities packaged pharmaceuticals and got paid 33 cents an hour, while the CEO was paid more than $400,000. I think if everyone understood that Americans with disabilities are getting paid less than their coworkers for doing the same job because of an 80-year-old law, I think they'd be horrified. I'm proud that Seattle became the first city government to eliminate the subminimum wage, and that my home state of Washington is one of 7 states that has abolished it as well. Mr. Lewis, in your testimony, you talk about how there was a time when you thought the subminimum wage made sense. And you talked about how you provided work to blind folks as a manager of a sheltered workshop where people with disability work in clusters separate from other workers. But then you were able to successfully transition nearly all your workers into competitive integrated employment. What was it that led you to realize that your workers were capable of more?
Thank you for that question, because that was that epiphany. I think that was the pivotal moment for me. One, in your opening comments, I think that you speak to a big problem. This is happening in a vacuum, and most of the people, when they're made aware, do find that it is atrocious. Then they fall subject to the existing misconception that people with disabilities don't have the capacity, and this is the least we can do to at least give them quality of life. But that's not balanced with the tools and strategies that are necessary to change that particular outcome. And that's what happened. We were thinking we were doing the right thing. But when we realized that if we implemented other strategies that we weren't aware of, we could create other opportunities. And I also think that it's important to recognize when we talk about looking forward to what could happen, that we look at what has happened. The data from Maine was back in 2015, but if you look at the data, there was an increase in employment of people with disabilities. If you start citing data from 2019 to 2020, we all know why those numbers were different than what the progression shown, and hopefully we'll return to that upward employability of people with disabilities post-pandemic. Again, I know that my testimony here today is probably not going to change the minds of those individuals who have been convinced that 14C is the right thing to do. But I can stand here or sit here as an example to say, I've been there. I understand that that's how you feel, and just charge you with really reaching out and finding out more truth to what is possible when we really look toward a more positive future. Lastly, I will say, I believe the Congresswoman said she was from Iowa when she was talking about her example. I thought that she was going to talk about the turkey farm incident, but I'm sure that what she was talking about was not the turkey farm, because the turkey farm was really the demonstration of how the 14C really does lead to just a horrific outcome. And I know that people say that's an anomaly, but as long as it's legal, it still remains a possibility.
Thank you, Mr. Lewis. Let me stay on that for a minute and go to Ms. Kopstein, because one of the things that always strikes me about this argument is we're talking about how wages are portrayed in terms of a person's worth. I mean, that's really, we're saying to people with disabilities, we think you're worth much less and we're going to pay you much less. And that really, really troubles me. For anybody, regardless of their abilities, there's support we need to give. There's things we need to do for people to be successful. But it bothers me to see sort of how the wage gets pulled into a person's worth. Ms. Kopstein, in your testimony, you speak compellingly about how your daughter was able to gain full-time employment and a decent living wage with benefits. What would you say to other parents who believe that the sub-minimum wage is necessary for their kids to have jobs?
I think you've nailed one of the key issues in this discussion. That is, a person should not be defined by one variable alone, productivity. A person is multidimensional, can bring different uniques and talents. My daughter's productivity may be lower while working at Costco compared to other of her co-workers who perform the same task, but she brings other attributes to the job that may not be measurable. And therefore, the wages in a company that has the foresight to hire people of different abilities with diversity, their bottom lines actually have been shown to be higher than their peers without that element of diversity. And so this would also address the motivation of employers. That's the inherent reason to hire people with disabilities, because of the multidimensional talents that they bring to a job.
Thank you. Thank you, Madam Chair. I yield back.
Thank you. Okay, Mr. Representative Good, are you on the platform, sir?
Yes, ma'am, I'm here.
Okay, go
right. Thank you, Madam Chairman. Thank you to our witnesses, and thank you again, Madam Chairman. Work in and of itself is invaluable in the dignity it provides along with satisfying a God-created need that we all have to contribute and be productive. In fact, we often identify ourselves by what we do. That is typically the first question we ask when we meet someone, because we all gain a tremendous amount of pride and self-worth from what we do. And I appreciate those employers and those organizations who are willing to stretch a little and give a break or a helping hand to those who are disadvantaged or at risk in some way. Both my wife and son actually work for a company that helps folks in these situations to obtain employment and to succeed in the workplace. Again, folks who are disadvantaged in some way or at risk in some way and need some help in obtaining and succeeding at employment. But Democrats seem to see discrimination in everything, whether based on race, gender, or disability. Democrats seem to look with contempt on all employers and job creators and presume the worst of intentions on those hiring and paying American workers. The fact is, there's value in providing employers a greater ability to hire someone who, because of some personal limitations, may not be able to perform at the same level of a typical employee. And the fact is, there's value in providing disabled employees more opportunities for employment, even if it's a specially reduced rate for those unable to obtain employment at standards rates. There's over 9.3 million jobs waiting to be filled. Yet Democrats' solution to this madness is to keep printing more money, spending money we don't have, and exacerbate the problem by finding more ways to pay people not to work. That's why last month I joined my colleague, Mr. Roy from Texas, in trying to help get Americans back to work by introducing legislation eliminating the $300 federal enhanced unemployment weekly benefit in an effort to fight against these efforts. Democrats' default response to businesses struggling to stay open, struggling to recover from government lockdowns and restrictions, is just pay them more. But as with the impact of forcing a minimum wage increase, Democrats don't seem to want to use real-world facts and evidence. They prefer anecdotal stories. Dr. Putz, I'm glad that in your testimony you mentioned the disastrous results that Maine experienced when that state eliminated Section 14C. Instead of helping people with disabilities, eliminating it actually hurt them. So we have a real live, real world example. This would no doubt be made much worse if the Democrats are successful in forcing through a doubling of the minimum wage. This is why when the U.S. Commission on Civil Rights requested feedback in 2019 on the 14C program, nearly 10,000 respondents were received, or responses were received, and 98% of those said that 14C should be maintained. 98% of the nearly 10,000 respondents to the U.S. Commission on Civil Rights asking if 14C should be maintained back in 2019. Dr. Putz, can you give a few examples of how this program has helped individuals by allowing them to experience the opportunity and the dignity of work?
Absolutely. And 98% of those comments were in favor of 14C and 1% were opposed. So I don't believe that HR 2373 respects the opinion of the individuals that did submit comments on that. Every day we have about 100 here at Employment Horizons, about 115 individuals coming in to work with us who get to see peers, have social interactions, perform real work for real companies. I don't want to, mention them in a public forum, but we have two huge telecommunications companies that we do work for, along with other Fortune 500 companies that you would absolutely recognize the names of. And these folks that are coming here are proud of the work that they're doing. They're proud of Employment Horizons. They're proud of the companies that they're performing work for. And as they acquire skills, we are taking the opportunity to place them into jobs in competitive integrated employment that I'm doubtful they would have received without that opportunity to work. We have some folks that recently got placed at an ice cream store. We have somebody recently placed in a local food store to us. I can talk about folks from the past that have worked in movie theaters and other settings, and the skills that they've acquired from their 14C employment has allowed that to happen. And for some of them, working in a hybrid manner where they split their time between a 14C environment and competitive employment is exactly what they need to maintain sort of the higher level of supports that they get in 14C and also maintain the employment that they need outside. And we support them in both of those options.
Thank you, Dr. Potts. I yield back, Madam Chair.
Thank you very much. Now, Representative Mervin, you recognize.
Madam Chair, thank you very much. I would like to thank all the witnesses. Have been in Congress as a freshman member for 7 months. One of the more memorable things that I'm going to take with me is John Anton, when you high-fived after your speech and celebrated doing such a phenomenal job. I want to commend you for all of that and for what you did and your contribution towards this. With that, my question is for Ms. Kopstein. In your written testimony, you mentioned the importance of the effective job supports and accommodations in helping your daughter, Monica, succeed in her job at Costco. Can you say more about the specific supports and accommodations she has received and how they have helped her?
Yes, certainly. The reasonable accommodations that Monica has received actually because her job coach has educated Costco about who she is and has communicated about any needs that might arise. Just during the pandemic, during the beginning weeks of the pandemic, when it was too chaotic, when people didn't know what to do, actually Monica took the benefits, vacation pay and time off to stay out, but she returned to work immediately after that. And she was able to be assigned work schedule early in the day when it's not so busy and when she is usually more productive. In fact, Costco has assigned her work schedule to recognize that. Costco has allowed Monica to take frequent time off for doctor's visits and also has exempted her from doing front-end tasks that are usually required of other front-end workers. For instance, she does not have to do shopping cart duties, which would be deemed too dangerous for her. She would not have to check membership cards at the front door. And they've tried to put her in to fold clothes and tidy up merchandise, but they found that was not the best suited skill. So she's really good at packing and unpacking merchandise into shopping cart, but that too was not something that she was born with. Her job coach had worked very hard with Monica to teach her this skill because, among other things, she has challenges in spatial planning, but she has prevailed. Someone in Monica's position is required to count the number of items in the shopping cart, but Monica is really not accurate in counting, and we're not talking about counting to 100. We're talking about counting to maybe 7 or so, as long as she can communicate and say that something is underneath the shopping cart. So some of those accommodations and flexibility has enabled Monica to thrive and be successful in her job, along with the job support she's received.
Thank you, Ms. Kopstein. Mr. Lewis, how can competitive grants under the Transformation of Competitive Integrated Employment Act help 14C certificate holders leverage what they have learned about working with people with disabilities in an employment setting in order to shift to a focus on competitive integrated employment?
That's a very good question. I'd like to add to the description of the job that was just given. Again, this is learned. So even in the individual's inability to count to a specific number, you could set up a little jig that allows her to put the contents in a container that only allows for the specific number that you want. So it's not even, I could brainstorm any number of ideas, but only do that because I've transitioned into my understanding of thinking out of the box and being creative around these employment options. The grants themselves will help us not only create an environment that the states who want to really invest in this and the centers that want to invest in this can continue to build on those learned behaviors, build on those best practices, but share them in a real way. I'll give a real quick example of something that I think is important here as well. As long as we continue to see people with disabilities as so uniquely different that we can't relate to it, we will continue to feel that we need to take care of these less fortunates. But if you look at the research that the Office of Disability Employment Policy has been doing to build on the customized employment strategies, customized employment is the strategy that's used to help people with significant disabilities get to work by engaging in what they call the discovery process, integration of job coaching and supported employment, and some job carving. All those sound like unfamiliar terms, but discovery is just what as an able-bodied person, before I went blind, I discovered every day because I had the opportunity to be engaged in different extracurricular activities. And even my first job at a grocery store had me experiencing a lot of different things. So I found out what I was good at, what I liked, what I didn't like. People with disabilities don't do that.
We are out of time. We're past time. Okay. Well, thank you very much. I want to yield now to Representative Fitzgerald. Is Representative Fitzgerald on the platform?
Thank you. Thank you very much, Madam Chair. I just wanted to highlight, after kind of thinking through some of the centers that could, and I'm not exactly positive on each one of the arrangements, but there are a number of them that are nonprofits within my district. And so the question is, there's kind of this misconception, I think, that employers are motivated by financial incentives. But fact of the matter is, I think the model could fall apart if, in fact, there was, something less than just an incentive to increase those. So I'm wondering if Dr. Putz could comment on that part of it, because I'm worried we could, without any intention, do some damage here that maybe we're unaware of.
I think you would, and I want to correct, I guess, some of the misconceptions, if I could, about the financial aspects of this, because I've heard a few even just today in terms of how the model works. There really is no financial incentive for an organization like Employment Horizons to have a 14C certificate. We don't make any additional money off of the contracts that we run by having one. In fact, my 14C program in our workshop actually loses money. If we break even, we would consider that a pretty good year. The way that the payment actually works, and we've heard some of the misconceptions about that this morning, is that we know on average how long a particular task takes non-disabled folks to do. And just to make the math very easy, if we know that the average is 10 widgets produced an hour and the prevailing wage is $10 an hour, then each widget is worth $1. And so, the average productivity in our shop is somewhere between 20 and 25% at any given moment. And so the 14C certificate allows us that if we need to hire 4 or 5 individuals to complete 100% productivity work, we can go ahead and do that. We're still providing a more intense supervision than a regular employer in the community is. And so there's actually added costs for us in having a 14C certificate, but it's our mission to provide those employment opportunities. And so that's simply how we operate. And I do think, when you talk about the more global model, that with 14C, if that were to go away, you would be losing both employment opportunities and also these instructional and training opportunities for a large number of folks.
Yeah, very good. I mean, my concern is just, let's do no harm. And thank you very much. I'll yield back. Thank you to the ranking member. Thank you.
I appreciate that. And, just looking and following up on that, I think it's important to realize, and Dr. Putz, you mentioned the learning potential that people have and what you do to help people develop skills that they can use. Maybe you could explain a little bit or elaborate a little bit on what you help people with.
Absolutely. So a large part of working in any setting is developing the soft skills. It's things as simple as showing up to work on time, and how do you take feedback from a supervisor, and how do you work cooperatively, the things that we all learn from having work experiences, especially some of those first and early work experiences that we have. But it's also really important for organizations like ours to make sure that we are introducing individuals with disabilities to the world of work beyond the 14C setting. So one of the things that we do is we have a Discover Your Community program, where we take individuals from our 14C settings out to local employers so that they can learn about jobs that exist in the community. Because if you've not had a lot of work experience, you may not realize the things that you see every day are actually jobs. We do job sampling, where we take folks from our 14C settings and give them paid opportunities to try out jobs at local employers. And we learn a lot about what their skills are. They learn a lot about what they like and don't like in a work setting, which makes it easier then to place folks. And in fact, on a number of occasions, those job samplings have turned into employment, competitive integrated employment for the clients that we serve. We do career counseling, career discovery, so that individuals might learn where their interests lie and the types of jobs that correspond to that. We hold groups so that folks learn to work together on things like developing interview skills, resume writing skills, how to find jobs that are of interest to you in the first place. And so, there's a whole lot that goes into it beyond I think what people think of 14C as.
Thank you. I appreciate that insight, and I yield back.
Thank you, sir. We want to recognize Representative Bowman. You are recognized, sir. 5 minutes.
Thank you so much, Madam Chair. My first question goes to Ms. Kopstein. Thank you so much for your testimony, which is a testament to your years of advocating for your daughter to ensure her voice was uplifted, particularly on the question of sheltered workshops. You also shared in your testimony that the recommendation to look into sheltered workshops came from your daughter's school transition team. I wanted to ask you, what are your thoughts or recommendations for schools to consider when it comes to supporting students with disabilities and their families with transitioning from school to work?
So WIOA from 2014 has recognized that pre-employment transition service, which could start as early as age 14 in New Jersey, would be one promising step. And even though my daughter's school has already recognized that before WIOA, the most important transition from school to work activities would be to provide opportunities of job skills in authentic settings, where students could learn skills in those integrated settings, because then they would not have to unlearn the skills, even if the students might be learning in the classroom. To transfer the learned skill from the classroom to outside of the classroom represents another learning step. Another important aspect is to recognize the presumption that everyone has the ability, the presumption that everyone can work, rather than having to limit the growth, the learning growth in a straight line by looking at work readiness skill. Now, work readiness skill is important. However, if a typical person is tested for his or her own work readiness skill, I would say that many of us would not be able to achieve what we've been able to, but people with disabilities and many in the special education schools and in sheltered workshops are limited because they are not able to pass all of the job readiness skills that in fact are obstacles. So the presumption of ability to work is really key to the success.
Thank you, Ms. Kopstein. Mr. Lewis, I would love for you to share your thoughts on the same question. What more can be happening in our K-12 school settings to set up students with disabilities and better prepare them for the world of work?
Yeah, as I was alluding to earlier, giving them the same experiences that our able-bodied students get. I think that one of the things we talked about in our group was people with disabilities don't get opportunities to experience real bad jobs in the real world, so that they can understand what they like, what they don't like. And I want to be very clear. I'm not trying to throw out the baby with the bathwater. I need to make sure that everyone understands that all of the good things that we're talking about, even Dr. Putz is talking about, can be done without the 14C certificate. When you introduce this 14C certificate, you can say you're doing these things in tandem, but I'll be honest with you, we had contracts to meet because of our subminimum wage environment. And when it was time to either do Job Club, but we had a contract that we needed these many widgets done by a certain time frame, Job Club was usurped. And we put those people back in the workshop to make sure we were able to deliver the products that we needed. The 14C is just counter to what we need to be focusing our energy on. And the school systems using the 14C environments as training institutions is not right. We need to be doing more of what Dr. Putz says, getting them out into community, looking at real jobs, getting an opportunity to see what they like, what they don't like, what they have the skills for, what they don't have the skills for.
Thank you so much, Madam Chair. I yield back.
All right. Thank you very much. Representative Thompson, you're recognized for 5 minutes.
Madam Chair, thank you so much. Thank you to all the witnesses. This is an issue having spent my entire career working with individuals that were facing and living with life-changing disease and disabilities. I really appreciate this hearing. Dr. Putz, thank you for being here today. You know, the Fair Labor Standards Act established the federal minimum wage, overtime pay, child labor, record keeping, and other wage and hourly standards for nearly 143 million Americans. And as you know, Section 14C of this legislation authorizes the Secretary of Labor to provide special certificates, more commonly referred to as 14C certificates, for certain workers whose capacity is impaired, living with physical or cognitive intellectual disability at wages lower than the federal minimum wage. And as of April 1st, 2021, the Department of Labor listed more than 600 employers with an issued 14C certificate, paying nearly 40,000 workers at subminimum wage, and almost 700 employers with a pending 14C certificate application. In my congressional district, many employers utilize the 14C certificate program, including the Cambria County Association for the Blind, the Venango Training and Development Center, ICW Vocational Services in Indiana, Pennsylvania, Progressive Workshop of Armstrong County, among others. These employers have argued for the continuation of this program, citing that it provides employment opportunities for individuals with disabilities who would not otherwise find employment. You know, 14C is not just about receiving a paycheck. This is about the power and the dignity of work. It's always been my opinion that work gives dignity to individuals, and these certificates offer individuals with disabilities, living with disabilities, a chance to contribute in the workforce, engage with other workers, have that that network, and to develop new skills. However, my colleagues across the aisle are considering HR 2373, which aims to eliminate this program entirely, forcing people with disabilities out of the labor market. And while I can support, I've always supported giving individuals the opportunity to earn more money, this should not come at the expense of eliminating opportunities for others. HR 2373, within that, by eliminating 14C, this will, based on my work experience and my observations today, spending a lot of time in these settings, this is going to result in pushing many individuals with significant disabilities over the poverty cliff, threatening the very safety net benefits that they rely upon. So instead, what we should be doing, and this comes down to the fact that as the Secretary of Labor that grants these waivers, we should focus on how the department oversees and implements this program. We should be doing our job as a committee of oversight with the Secretary of Labor in order to make sure that they raise their standards and allow these individuals to thrive in the workplace. Where there's a problem, there's a violation of the law that already exists today. So Dr. Putz, I wanted to reiterate what my colleague from Virginia said earlier. In November 2019, the U.S. Commission on Civil Rights received nearly 10,000 public comments when soliciting opinions on the future of the 14C program, 98% commenting that the 14C program should be maintained. This clearly shows how we should look for ways to improve the program and not eradicate it altogether. So Dr. Putz, in your opinion, does HR 2373 respect the ability of individuals with disabilities to select an employment setting that meets their needs?
So I think it clearly does not, based on those figures. 98% of the comments, like you said, were in favor of 14C. If we're to judge 2373 in light of those comments, then it's not matching the feedback that the U.S. Commission on Civil Rights received. And in my opinion, self-determination and choice have to be the underpinning of any good system of employment for people with disabilities. And what HR 2373 does is take away certain choices. There's clearly not an insignificant number of people with disabilities who want to maintain 14C options. And I sort of reject the attitude that others know what's best for them instead of allowing them to make those choices. I also appreciate your comment on fixing things when there are errors, as opposed to trying to sort of throw apart the whole system. Some of the examples that we've heard this morning are definitely not best practice or things that employers with 14C certificates should not have done. But if there are folks operating out there that are not operating appropriately with the 14C certificate, then we need to address that, as opposed to deciding that the entire program doesn't work.
Thank you, Doctor. Madam Chair, if I may, before I conclude, I'd like to submit 2 letters for the record. The first is from the Venango Training and Development Center, located in my congressional district. Second letter is from the Rehabilitation and Community Providers Association. Both letters outline the impact of eliminating the 14C certificate program.
So noted. Thank you.
Thank you, ma'am.
Okay, thank you very much. Representative Cawthorn, you're recognized for 5 minutes, sir.
Thank you very much, Madam Chair. The facts are abundantly clear. The Biden administration's policy of exorbitant unemployment benefits has been counterproductive, and the American workforce has stalled in returning to work. Our local businesses need safe, effective labor in order to kickstart our economy. If there was ever a time to work on disability pay, now is the time after a global pandemic, and where businesses need workers more than ever. Now, I personally do not believe in any form of a federal minimum wage, but if there is going to be a minimum wage, we should treat all citizens as equal under the law. The strength of human dignity is fully realized in a good job and a firm work ethic. Given the right resources and building on existing programs, we can transition capable employees into our workforce. I urge my colleagues to consider this legislation, and with that, I yield back.
All right. Thank you, sir. Let's see. The Representative Steele, you on the platform? Representative Steele, you're recognized. 5 minutes.
Thank you, Chairwoman. Thank you for all the witnesses for testifying today, and I really appreciate it, and staying long hours. And I just want to have a question to Dr. Potts. Hopefully everyone agrees that individuals with disabilities should have access to employment opportunities, and Congress should empower people to make the best choice for themselves. Should we respect the abilities of individuals with disabilities to select an employment setting that best meets their needs? Who should make that decision? Should Congress take away options available to individuals with disabilities?
Thank you for that question. As somebody who works in the vocational rehabilitation field, choice is really the primary thing that we support. And all of us get to make choices about the employment settings that we work in. And so people with disabilities really should not be treated any differently by Congress or any other organization. And so I think it's important that we recognize that there are people that may make a choice that is different than the one that we would make, or that we might make for a family member, and that we have to preserve that wide range of choices. And so I don't think that 2373 allows for that. And everyone's situation really is so different that we have to allow them, in conjunction with their family and other supportive others, to make the choice for the situation that best fits their needs.
Thank you for that answer. I have a second question. If someone in California loses the ability to use Section 14C of the Fair Labor Standards Act, can organizations like yours, Employment Horizon, successfully transition everyone to another opportunity in a competitive, integrated employment setting?
So the data we've seen so far suggests no. There are certainly individuals that could and would be transitioned into competitive integrated employment. I don't believe they would be working the same number of hours that they are now, and ultimately they would probably earn less pay overall. But certain folks would be able to be placed in competitive integrated employment. My fear is that there's a large number, and some folks also would take advantage of the opportunity either to retire or to move into day programs due to age or other factors. So who I worry about are the folks that are in the middle, the clients we serve that are not going to be able to be placed in the competitive integrated employment or don't want competitive integrated employment, and the folks that want to do more or want to continue working and don't want to be in a day program or retire. And those are the individuals that I really worry about in this situation.
Thank you very much. I yield back.
And thank you. Let me recognize the chair of the full committee, Representative Scott. You are recognized, sir.
Thank you, Madam Chair, and thank you for this hearing. First, I'd like to introduce a letter for the record, ask United States to introduce a letter for the record from Representative Kathy McMorris Rogers in support of the legislation.
Noted. Thank you.
Thank you. Mr. Lewis, for people that are presently on 14C certificate, how can wraparound services, supported employment, job coaches allow transformation to competitive integrated employment?
Thank you for that question, because it allows me to elaborate that that's the only time that the individuals really do have an opportunity for real choice. We've been talking about choice, but in the example that was given about the individual who went to that competitive integrated work environment and said that as a result of some circumstance related to her disability, she went back to the shelter workshop. Again, it's easy to use that as an example without taking into consideration, did we put in place the proper job coaching to help her be able to be productively employed in that environment? Did we provide the wraparound services that included not only supports on the job, but also in her home life that allowed her to do this, that would have reduced or even eliminated the subsequent impact that the seizures or whatever happened? There doesn't seem to be a legitimacy in saying that those same supports that were provided in that segregated environment could not have been provided in a competitive integrated work environment. And once you get an opportunity to be exposed to all of those supports in that opportunity, I think that it's common knowledge that anybody on this committee would make the choice to be in a more integrated work environment, making a better wage, hopefully with better benefits. I don't see how anyone could say that choice would be different.
Mr. Lewis, are you aware of any programs that give wage subsidies to help bring up the pay?
Yeah, I mean, I could give many examples. One that speaks to me, to my heart, is when my brother was employed at the workshop in Georgia. Not only was he given kind of a wage subsidy because they were saying that they wanted to make sure he didn't lose his Social Security benefit, in those instances where his productivity did end up, based on that flawed commensurate wage formula, make more than he was eligible for, what they would do is they would put money back to actually reduce his income, never even give him the opportunity to make enough money to escape public assistance.
Well, if you can give us, if you could provide for the record those kinds of programs, we'd appreciate it.
Yes, sir.
Dr. Putz, one of the problems we have with this issue is that the Supreme Court has spoken with the Olmstead decision about getting people into the least restrictive environment. The Americans with Disabilities Act has prohibited discrimination. Disability advocates are coming to a consensus that 14C is obsolete. In fact, several states have just eliminated 14C altogether. And the number of 14C certificates is going down. And so one problem we have is the debate seems to be, if it's not over already, it's on the way to being over. You indicated that you shouldn't end it without a reasonable replacement. How does this legislation serve as a reasonable replacement for 14C?
Well, unfortunately, I don't think this legislation does serve as a reasonable replacement for 14C.
Okay, in that case, what provisions would be necessary to serve as a replacement?
You know, I can give you some of my sense, but this might go beyond my expertise here. One of the things that certainly could be looked at is subsidized wages, so that organizations like Employment Horizons could pay the individual with a disability the prevailing wage or the minimum wage. The individual would then earn a full wage and hopefully be able to come off of other forms of public assistance, but without making it impossible for organizations like ours to continue operating. My issue with 2373 as it stands, and I want to be clear, is I want individuals with disabilities to earn as much as they possibly can and to have as much career mobility as they possibly can. I just don't think that we're in a situation, at least the situation yet, where we can do that by simply shutting down 14C. And this legislation puts money into states in disseminating information and best practices. But the ultimate reality is that right now employers have access to individuals with disabilities, and yet only 20% or so of individuals with disabilities are in the labor force. And so it's not that employers don't have access to these individuals. We're looking at grant funding to change the hearts and minds of employers, and I don't think grant funding can do that.
Okay, thank you. Mr. Lewis, both ranking members of both subcommittees and Dr. Putz have indicated that if we eliminate 14C, there will be some people that won't be choosing between $2 an hour or $7.25 an hour, but they'll be choosing between $2.50 an hour or they'll lose their job. What happens to the people that cannot get into competitive integrated employment if 14C is eliminated?
So first, I'd like to offer the perceived impact that eliminating 14C, and again, we're not eliminating, we're phasing out the use of it, would have on the unemployment rate. Well, the act was introduced in 1938, and the employment rate of people with disabilities has hovered around 75, unemployment rate has hovered around 75 to 80% for these many years, except for the last few, when there has been an increase in the employment rate of people with disabilities. So 14C existed in those years. The only thing that's really changed is the move toward eliminating the use of 14C, toward engaging in competitive integrated employment strategy. So I think that's important to note. And I'm sorry, I went to that without answering your question, if you could really.
Well, what happens, what can we do for those who may lose their job?
Good, so what we need to understand is that 80% that's unemployed now, they're the ones who are currently being adversely impacted because 14C exists. It shapes the minds, paradigms, and perception of employers around the capacity of people with disabilities. But we see now that those individuals who have been unemployed are gradually becoming employed in a competitive integrated environment. So I think that that in itself signals that we're on the right path. We're moving toward the right trajectory.
Thank you. Thank you, Madam Chair. You're back.
Thank you, Mr. Chairman. Mr. Grothman of Wisconsin, who's a member of the full committee, but not a member of either of these subcommittees, is joining us today, and he's requested to wave onto the subcommittee and to ask questions of the witness. So, Mr. Grothman, you are now recognized for 5 minutes.
Thank you. I can't think of a bill I have more of an interest in this session, and it's not a positive one. I like our chairman, but first of all, I'd like to make a statement. Before I begin my questioning, I'd like to submit the following documents into the record: a statement in support of 14C and a full array of employment choices for individuals with disabilities from the Disabilities Service Providers Network, a statement in opposition to 2373, the Transformation to Competitive Integrated Employment Act from the A-Team, a great grassroots advocacy organization, and finally, my constituent friend Yael Curzon, her personal story of her experience working both in the community and with her CRP called Northwoods.
So noted.
So thank you. Now, I would also beg members of the committee, before we ever take any vote on this, to personally tour some of these facilities themselves. I have 10 in my district. I don't know how anybody could tour these facilities and see how happy the employees are to have a 30 or 35 hour a week job like their siblings and friends. To get rid of it, I just think you're taking such a wonderful choice away from people. And I think it's quite frankly anti helping these people to have Big Brother come in and say you can't have that option. I have talked to people who move to something in the community. Either that job is a 6 or 7 hour job instead of a 30-hour job, or they just don't like it because they like so much the current settings. And it is so arrogant to force these people to work in the community when they would prefer to work in these facilities. And I beg other members of the committee to tour these facilities in their district. Now, Dr. Putz, couple things. We have been told by one of the other committee members that people want to get out of these facilities and everybody would rather work in the community. I don't find that true when I talk to people. I find people who worked in the community and regret it and want to get back. But I want you to comment on that quickly.
And I'll go back to everyone as an individual. There are absolutely folks that are very happy working in a 14C setting and wish to remain there. And there are folks who have aspirations for competitive integrated employment. And it is 100% our job to help them reach that when that is their goal.
Is there a difference, do you think, a little bit between people with physical disabilities and more mental disabilities?
Sure. And again, everyone with a disability is so different. So there is a definite difference between intellectual and developmental disabilities, which is predominantly who we serve.
Right. Next question I have, and I think it's going to be particularly a big problem for people with mental disabilities. But next, when they say we found employment for people, one of the things that I find is they exaggerate because someone goes from a 35-hour-a-week job to a 6-hour-a-week job, and they say, aha, we found a job in the community. And the rest of the time you're babysit in a daycare setting. And people know very well that they lost their job and they're miserable. And I think to count finding a 6 or 7 hour job to replace a 35-hour job is just so unfair. But I'd like you to comment on that.
Yeah, and it's not a replacement. It's certainly an interesting opportunity for someone. Competitive integrated employment is always a worthy goal for individuals, but 6 hours doesn't replace 30.
Right. That it's just so dishonest. I'm going to say too, I think frequently you find a 6 and 7 hour job. It's not that it's not only a different job for the employee, it's a different job from the employer. I find a lot of employers in my district, when they do offer the 6 or 7 hour a week thing, they view it as charity all the way. They're not getting a lot out of that employee. The employee knows it, but we create an expectation in our society, which is wonderful, and that a lot of employees feel it's their goal as a good citizen to, in essence, kind of sadly babysit this person for 6 and 7 hours a job. And that's fine. And it's wonderful to be out in the community. But I sometimes think certain advocates miss that. Do you feel that's the attitude of some of the private sector employers, that they view it as more of a charity than we found this employee?
I think a lot of employers want to do what they consider to be the right thing, that they want a diverse workforce. And I think increasingly understanding that people with disabilities are part of a diverse workforce is becoming more common. But at the same time, if the position made sense at more than 6 or 7 hours, then I'd like to think the employer would offer the position.
That's exactly right. I find that again and again. People hired for 6 or 7 hours a week, and everybody says how wonderful it is, but miraculously, the employer says how wonderful it is. That employee never moves up to 14 or 15 hours a week. There's a reason for it. Do you feel that people have more job security in formerly called workshops than they do out in the community? Another thing that concerns me is, businesses open and close, and consistency and security is so important for that population. I find frequently that when people get jobs in the community, restaurant work is common. Restaurants open and close.
You're out of
Much
time.
more traumatic. Oh, okay.
Yes,
Madam,
we are past time.
thank
Yes.
you much. I again beg members of the committee to tour these facilities in their district. Thank you for
Thank you
having
very
me.
much. Let me quickly recognize Representative Stevens.
Hey, thank you, Chair Adams, and thank you, Chair Bonamici, and of course, Chairman of the full committee, Mr. Scott, as well as our just incredible witnesses. This hearing was not only informative, it was essential. And as we look at Section 14C of the FLSA, which allows employers to apply for special certificates from the Department of Labor to pay individuals with disabilities less than the federal minimum wage. We've heard a lot today about how changing the law would be cumbersome for the businesses. It'd be cumbersome for the businesses, except for they're still going through an application process to pay less. And what we heard through our remarkable testimony from Mr. Anton from Ms. Kopstein to Mr. Lewis here, it's absolutely remarkable that in the year 2021, this is still going on. This is still going on. We have places in Michigan, in my district, some of the gold standards for adult higher ed learning for the disability community, from Visions Unlimited to the Learning Enrichment Center located at the Novi Northville border that's focused on not leaving behind human talent. And yet the value that we are placing on this talent is less than in the year 2021. So yes, this hearing couldn't be more essential for us here today, as we are balancing some very profound considerations with workforce development, a constrained labor market, and on. Mr. Lewis, in particular, in the Workforce Innovation and Opportunity Act, which requires vocational rehabilitation agencies to provide career counseling and other services to youth with disabilities before they can be employed at sheltered workshops, which is a term that I don't even know why we are using. Frankly, I don't even like that term in the United States of America. Based on your observations, to what extent, Mr. Lewis, and how effectively has the counseling requirement been implemented?
The counseling requirement is only going to be as good as the professionals' knowledge of what the true opportunities are, which was one of our concerns when we were looking at passing the reauthorization. I'm so pleased that the Workforce Innovation Opportunity Act recognized that that transition age is crucial. And we need to set high expectations for our students with disabilities to strive for the same goals as everyone else, regardless of what society feels their capacity is. We have proven strategies, interventions, and supports that make it possible for them to be in the same environment with the peers that hopefully they're engaging in the school systems. It's just pivotal that we need to do that. But if there are individuals, and again, I was one of these individuals that is advising these people that 14C is a viable option, and my arrogance was that I thought I knew what was best. But luckily for me, I was open-minded, and people who proved to me over and over again that the ceiling that I had placed on these people, the limitations that I had placed on these people were false and wrong. Once I broke through that ceiling, then they were able to get those true access to those true opportunities. So I think that's what's important. The counseling has to be supported through individuals that have the knowledge and the belief and the capacity that these students can be competitive.
Great, thank you so much. And I know we are over on our hearing time, but just allow me again to thank you for your work, to thank you for your testimony. God bless you and your families, Mr. Lewis, Ms. Kopstein, and Mr. Anton. You are remarkable individuals and part of the progress that we are making for the people in the 117th legislative session of the United States House of Representatives. Thank you, Madam Chair, and I yield back.
And thank you very much. And let me remind my colleagues that pursuant to committee practice, materials for submission for the record hearing must be submitted to the committee clerk within 14 days following the last day of the hearing. So by the close of business on August 4th, preferably in Microsoft Word format. The materials submitted must address the subject matter of the hearing. Only a member of the joint subcommittee or an invited witness may submit materials for inclusion in the hearing record. Documents are limited to 50 pages, no longer than 50 pages, or documents longer than 50 pages will be incorporated into the record via internet link that you must provide to the clerk within the required time frame. Please recognize that in the future that link may no longer work. Pursuant to House rules and regulations, items for the record should be submitted to the clerk electronically by emailing submissions to edandlabor.hearings@mail.house.gov. Again, I want to thank the witnesses for their participation today. Members of the Joint Subcommittee may have some additional questions for you, and we ask the witnesses to please respond to those in writing. The hearing record will be held open for 14 days in order to receive those responses. I want to remind my colleagues that pursuant to committee practice, witness questions for the hearing record must be submitted to the majority committee staff by committee clerk within 7 days. The questions submitted must address the subject matter of the hearing. I want to recognize the distinguished chair of the CRHS subcommittee, ranking member. The chair of the committee, the ranking member for a closing statement. That's Representative Keller. Oh, Representative McCain? Representative Keller. Okay. Thank you, sir. Go ahead. You're recognized.
Thank you, Madam Chair. And I'd like to thank the witnesses for your testimony today and for being here to help us understand more about your experiences. The hearing made one thing clear. Both Democrats and Republicans want people with disabilities to reach their fullest potential. While we may disagree about potential public policy changes, I hope we can agree that we should avoid actions here in Washington, D.C. that foreclose opportunities for our constituencies. Sadly, H.R. 2373 would have many potentially detrimental consequences for workers with disabilities, and I do not believe my Democratic colleagues take these downstream costs seriously, and I am not alone. Madam Chair, I ask unanimous consent to enter into the record 3 letters and 2 statements, all supporting the 14C program. The first letter is from the Rehabilitation and Community Providers Association in Pennsylvania. The second letter is from members of the Missouri Congressional Delegation to Congressional Leadership. The third letter is from Rep. Vicky Hartzler to the chair of the U.S. Commission on Civil Rights. The first of the 2 statements is from Project CU, Incorporated in St. Louis, Missouri, and a second is from Access in Washington, D.C.
Noted.
And additionally, I would ask that unanimous consent to enter into the record documents from Mr. Grothman.
Yes, I noted.
Okay. Thank you. All of these statements and letters for the record plea with Congress to protect the over 100,000 14C employees from becoming unemployed. Let me be clear, Republicans support the ability of individuals with disabilities to work in a setting of their choice, reaching their fullest potential, including under 14C certificates. Eliminating 14C is wrong. People with disabilities find meaning in these jobs, and it is heartbreaking that Democrats want to take that away from them. I want to help individuals with disabilities find the best and highest paying jobs possible for their unique circumstances. I thank you, thank the witnesses, and I appreciate the helpful testimony. I yield back.
Thank you. I want to recognize now the distinguished chair of the Civil Rights and Human Services Subcommittee, Chair Bonamici, for your closing statement.
Thank you so much, Chair Adams, and thank you again to our witnesses for your insight, for your expertise, really sharing your stories with us. It really makes a difference. And as we heard today, clearly, this 14C subminimum wage is a relic of an era when employers were legally permitted to discriminate against individuals with disabilities in the workplace. That era is long over. Since the passage of the Fair Labor Standards Act in 1938, Congress has taken several historic steps to make sure that children with disabilities have access to free and appropriate education, that people with developmental disabilities can access services and individualized supports, and that all Americans with disabilities have equal opportunities. And despite this progress, workers with disabilities in some states continue to legally be paid less than $2 an hour. It's unacceptable. Now we have the ability to rectify this injustice. By passing the Transformation to Competitive Employment Act, we can protect the civil rights of workers with disabilities and join states across the country in supporting workers with disabilities and helping them succeed in competitive and integrated work. So thank you again to our witnesses, and I yield back now to Chair Adams.
Thank you, Chair Bonamici. I want to recognize the distinguished ranking member of the Civil Rights Human Services Subcommittee, Ranking Member McLean. You're recognized for your closing statement, ma'am.
Thank you, Madam Chair. As I said during my question time, members of Congress must not let our passions get the best of us. We need to evaluate legislation using facts. Feelings are not important in determining legislation, but our constituents care more about how our actions affect them than they do about how we felt about our vote. And the facts show that Democrats will eliminate jobs for individuals with disability if they pass H.R. 2373. Dr. Putz acknowledged some 14C3 employees may secure competitive integrated employment, but a majority of them will not. Eliminating job opportunities is not why our constituents sent us to Congress. Democrats attempt to institute a one-size-fits-all competitive integrated employment world ignores the legitimate instances when 14C3 environment is appropriate. The Democrats' bill will also fail to consider other important entity in the equation: employers. Businesses do not have unlimited resources, and not all of them will be able to afford to offer individuals with disabilities a position on staff if the Democrats' proposal is enacted. I believe current law offers individuals with disabilities the chance to contribute, engage with other workers, and develop new skills. There is dignity in work, and no amount of taxpayer funding can change the fact that H.R. 2373 will strip this dignity away from too many workers. We must respect workers' choices. We must make sure different workers have different work environments to pick from. We must carefully weigh the evidence, and the facts do not support the Democrats' position. Thank you to all of the witnesses for your contributions today. I wish you the absolute very best. And thank you, Madam Chair. I yield back.
And thank you. I want to recognize myself now for the purpose of making my closing statement. Thank you all for an engaging conversation. Thank you to our witnesses for sharing your expertise and advocacy. Today's discussions and expert testimonies reaffirmed our responsibility to not only end the 14C subminimum wage, but also to help providers and workers with disabilities transition to competitive integrated employment. As we heard, many states and cities across the country have already taken the initiative to phase out the 14C subminimum wage. The integrated workplaces in these states prove that with the necessary investments, it's possible to create an inclusive workforce in which all workers can meaningfully contribute to their communities. And this is why we must pass federal legislation, including the Transformation to Competitive Integrated Employment Act, to ensure that all working Americans with disabilities are given the tools that they need to succeed in our economy. And finally, I'm submitting two statements for the record, one from the National Council on Disability, an independent federal agency that has recommended the phase out of 14C since 2012, and one from Melwood, a nonprofit employer of people with disabilities that stopped using 14C certificates 5 years ago and has been a leading voice for the transformation to competitive integrated employment ever since. Without objection, so ordered. The letter from the NCD's chair states that the transformation to competitive integrative employment, H.R. 2373, would provide, and I quote, states and individual providers with resources from subject matter experts in order to transform their business and program models away from the outdated subminimum wage model and into a new model that supports opportunities to enter competitive integrated employment. The letter from CEO of Melwood states that, and as I quote, as one of the largest employers of people with disabilities on the East Coast and as an employer that formally held a 14C certificate, we firmly believe Congress should act in the use of these certificates and embrace the future of disability employment policy that acknowledges all the work over the past many decades to improve opportunities for people to live, work, and to play in their communities. And so as we approach the anniversary of the ADA next week, this is a timely moment to take stock of how we move past this antiquated provision of the FLSA and work to achieve the goals of the ADA by committing to opportunities for competitive, integrated employment for people with disabilities. If there is no further business and without objection, the joint subcommittee stands adjourned.